Good morning, everybody. I'll probably give a slightly different perspective of what you've heard today. I'm afraid I wasn't here earlier on, I had to fly in. But I'm going to go straight to the legal aspects of what's important here for health and safety. And I've been involved really since the beginning. I was junior counsel on the first defended health and safety case in New Zealand back in '94, the Dispar case, which was a case that set some very important aspects of health and safety for us. What I'm going to do today is I'm going to look at the current Act, Health and Safety and Employment Act and regulations, look forward to where the review is taking us, and that's the Health and Safety Reform Bill, and all things going well, that should be in place in 1 April next year, and even with a change of government, I suspect it will still come in pretty much in that form. And I'm going to have a little look at Australia because we've copied our proposed law very heavily on the Australian law, and it's been in place there since 2011, so we have some guidance as to what's occurring in Australia, which I think will be very helpful for us here in New Zealand. I'm looking at it in terms of both fatigue and impairment. So fatigue is both obviously mental and physical fatigue, but also impairment. I'm going to touch on drugs and alcohol, and many of the cases I've looked at, drugs and alcohol actually go hand in hand with fatigue. So I'm just going to touch on that. So I'm going to start with the definition, and I've printed it out in full because I think it's important that you see what we have in place. The first part of the definition has been in place since the Act came in '92. The second part, where we talk about includes, actually came in 2003. So as a country, New Zealand didn't recognise the activities of other people as being a health and safety hazard till about 2003. And you can see specifically there, the current Act is all about harm, and it's talking about the activities of a person, and goes forward to talk about the physical or mental fatigue, drugs or alcohol. And those are things which it says are situations described that may result in a hazard. Now that can be anything from someone in your organisation who is a bully, through to someone in your organisation who's fatigued, and someone who perhaps is under the influence of alcohol and drugs. And remember, when we talk about drugs, it's not just illegal drugs, it's also legal drugs that impair you. And there's been a number of discussions about that as well. And so what I've done is I've just picked up on some cases, and my discussion today is not going to be a general discussion about the Act, it's going to be more specific about fatigue and impairment, and we'll relate that back to construction where we can. But these cases are quite important because they have led from different jurisdictions into the health and safety area why we see fatigue and impairment as being important. And the first case is from the Employment Court. Judge Palmer, who's now retired, talked about the miscreant person, a person who's a wrongdoer, is another way of putting it. And he said a miscreant person can be both a hazard and, in certain circumstances, a significant hazard as defined under the Act. And of course that case was in 2000, so that kind of led through to the amendments in 2003. So from a court perspective, and this was employment court, not health and safety, there's a recognition that a person's activities or lack of activities can be a hazard. And you've got to remember the hazard is about not only the hazard to other people, but also the hazard to that person themselves. So that person coming to work who is fatigued or impaired in any way, they can be a hazard to themselves, and that can create for the employer and for that person some liability under the Act. But the second case is an important one. It was only Employment Relations Authority, but it involved the fire service in 2009. And there was an individual who was physically able to come back to work and act as a fire person. But the employer held that they weren't mentally up to the rigours of being a fire person. And the important aspect from the employer's perspective was, if we have fire people going into a situation, you need to be able to not only look after yourself, but also look after other people. So that case recognised quite clearly that, again, you can be a hazard not just to yourself, but to another person. There has been one successful stress case in New Zealand in terms of directly on point. It involved a small engineering firm up in Nelson, where a person had too much work placed upon them. And again, the concept of hazard in the environment in terms of the activities of that person and the lack of the employer's activities in trying to protect them was acknowledged in that case. And in that case, the employer was fined. So These cases, I think, go to establish that it is the activity of people in an organisation that can create a hazard, not just for themselves, but for other people. Since 2003, the courts have recognised that as an organisation you can be prosecuted, and we know that as part of that, fatigue and impairment are important aspects. I've just mentioned 3 other cases there. They are employment cases, so they stand alongside health and safety, but they involved a police officer who was video recording awful scenes, from murders to fatalities and car accidents, and he was doing too much, and the employer allowed that person to do too much, and he went on and became stressed and unable to work. And he had a successful claim from an employment perspective, but from a health and safety perspective, it's really important, and I think we'll see this later, that even if it is the employee who is at fault, the employer still has the obligations, whether it's from an employment perspective or a health and safety perspective, to ensure that they're not harming themselves. The probation officer, someone in South Auckland who had too high a workload, and the immigration officer, an immigration officer who went over to Asia after the tsunamis. And again, in all of those cases, the employees were doing what they were supposed to do under their job description, but the employers weren't protecting them, weren't providing a safe work environment. Right, so this is the proposed law. The one thing about the Australian law which I quite like is that it's very simple. What they've done is they've actually cut back a lot of the wording we have in our law, and they've made it very simple. But in doing that, I suspect it's going to have a wider application. So, for example, they talk about a hazard being a situation or thing. Under the current definition of hazard, we talk about an activity, arrangement, etc., etc. So the Australians have simplified it down quite a bit, which in my view means it's going to be a lot wider. And they go on, and they've mentioned there, again, almost similar wording, physical or mental fatigue, including drugs and alcohol. So it is an emphasis under the new law, but they're looking here at only a potential to cause. So a hazard is going to be somebody who is fatigued that has the potential to cause death, injury or illness to himself or someone else. So you don't actually have to have an accident following or an injury following or an illness following. It's just the potential to cause. And so if you have that potential to cause, it's a hazard and you can be subject to prosecution. So here's the Australian model. What the Australians have not done is they have not defined hazard in their Act. So the Australian Act has actually kept away a lot from the definition of a number of different important terms. And when the bill first came out in New Zealand, we weren't going to define hazard either. The exposure draft did not define hazard. It's subsequently been brought back in because of the importance of that term. Now, the Australians refer to it in a large number of sections. I've given you some examples there. So the hazard is a very important part of the Australian legislation, but it's not defined. But what they do have is a draft code of practice. And I think this is a very important document. Given the similarity between their Act and our proposed Act, I suspect this code of practice will become important in New Zealand in terms of what the government here develops. It's not a long document, and I'd recommend, if you wanted to find something to look forward in terms of how you deal with fatigue and impairment, I would look at this. Safe Work Australia, just go to their website and you can easily pick it up. It does say draft. I'm not certain if it's been finalised, but certainly it is an important document. And the interesting thing about this document, and it's the same in New Zealand, is it states specifically that it can be used as evidence in any court proceeding. So this document becomes evidence in the court proceeding as to what's acceptable in terms of identifying and eliminating or minimising hazards such as fatigue or drugs and alcohol impairment. So it's a very important document, and I'm not going to go through it because I'm sure some of the other speakers have discussed these aspects, but what it does do is it defines fatigue, and I think that's a very similar definition to how in New Zealand we see fatigue. But it talks about work versus lifestyle, and I think this is a very important aspect of trying to identify fatigue and what, as an employer, you're supposed to do. There are a number of aspects in terms of what causes fatigue at work, and I think we heard before from the union perspective a number of those aspects. It's long work hours, it's lack of sleep and so on, and difficult shifts. But also there is this lifestyle concept, and for me I struggle with how an employer can go into an employee's personal lifestyle to find out what's going on. Do they have issues at home, financial issues, relationship issues? Are they partying a lot? Are they someone who has a sleep disorder? How, as an employer, am I entitled to find that out from an employee? Well, I think the answer is that you actually have to now. And if an employee is not going to be forthcoming with this information, you have to decide, well, do I look at what I've got going on here and do I decide there is an issue, and do I demand this from the employee? Is it fair and reasonable? I don't know the answer to that yet, and under the new Act we'll find out, but taking all practicable steps, and under the new Act taking reasonably practical steps, might well require an employer who assesses somebody who has elements of fatigue to explore what's going on in their personal lifestyle. We then look at what are the signs of fatigue, and again I have an issue with this in terms of, in most organisations you don't have a doctor or a psychologist or a psychiatrist or anybody who's actually qualified to sit there and say, well, from a medical perspective, I think this person's got fatigue. But what I think you do have is you have managers who can be trained in this area and who can have a check sheet effectively. And there's a check sheet here, and if you look through it, I suffer from most of them myself most days. But if you combine them all and they're quite serious, then clearly this is somebody who may be suffering from fatigue. From headaches to being disconnected to blurred vision to yawning, moodiness, and so on. So that will take an appropriate person within your organisation actually assessing people as to whether or not they're suffering from these elements. The issue there, of course, is that if you have a large organisation, you've got to delegate that down. I mean, directors can't do it, your CEO can't do it, so you're going to have managers who assess this. And things such as taking excessive sick leave might be a sign. Someone who is found asleep at work, those sorts of things. And then we come back to who is responsible for managing fatigue, and this is a really important aspect from a health and safety perspective. The PCBU, which is the new term under the new Act, and currently the employer, you are the ultimate, you have the prime responsibility. So you have the responsibility to assess people at work, you have the responsibility to see what's going on in their personal life to a certain extent, to see whether or not they're fatigued. That's a hazard either to themselves or someone else. But then it comes down to other officers within the organisation. And I don't suggest a director needs to assess people personally at work, because they can't. They are the governance of the organisation. But directors must require the managers and people reporting through to the managers to have that obligation upon them. Training and supervision is another very important aspect. And under the current Act and under the new Act, monitoring employees is important. Providing information to employees is important. Certainly training is important. And supervision. And I think training can be both on those managers and appropriate people to assess if someone has fatigue, but it also can be on your staff to let them know when they have got fatigue so they can actually identify it themselves. And lastly, there's a very helpful checklist and assessment guide at the back in the appendix, which, for current purposes, while it's Australian and while it's part of a draft document, it's something which could be helpful for you yourself, along with the New Zealand documentation, to draft something up so that you have some form of policy at work. So in construction, we've done an extensive search and we haven't really found any direct cases that deal with fatigue or impairment being the primary cause or result of an accident. There are a number of cases where it's subsidiary, and certainly there's a number of cases with drugs and alcohol. But I have found one case which I'll talk about soon through a coroner's court, which was quite relevant. But the issues for construction, and look, I'm only just suggesting a couple, and there's clearly a lot more, but obviously drugs and alcohol. And it's not just the illegal drugs that we're finding, it's the synthetic drugs. As soon as the government outlaws one synthetic drug, another one will pop up, so your party pills and those sorts of things. And it is also your legal drugs. If you go to the packet of a legal drug, whether it's prescription or across the counter, and it says do not operate heavy machinery in the next 10 hours, and you pop a pill that morning, well, what does that mean? Is the warning just there for no purpose, or does it mean don't operate machinery? I know some organisations will say that you must come in and advise if you're on any legal or illegal drugs, and if you're silly enough to advise you're on illegal drugs, good luck to you. But you must advise if you're on legal drugs. And what happens there is the manager who's seeing you will say, well, I will assess you as to whether you can operate heavy machinery, and that's fine. The shifts issue, and it's about, how long are your shifts? What is the recovery time between shifts? What are you doing on your shifts and so on? Dangerous circumstances. Well, construction is, and I use this word with some of my clients, you have an inherently dangerous business, and they say, oh, no, it's not, but it is. We kill upwards of 100 people a year in work in New Zealand. The aim of this new act is to reduce that by 25% in the year 2020. What that means is that we're only going to be killing 75 people a year. It still means people will die in work. And so there is an inherent danger in a lot of businesses. And I think interesting before from Kirsten was that 100 odd people who die directly from work, it's that large portion of people who die from illnesses or injuries, illnesses arising out of work, and fatigue and stress, leading to the likes of heart attacks and so on. That's the unknown. And so it's obviously a very important aspect. So this is a case I found. It was a coroner's case somewhere up Whangarei Way back in 2004, and there was a construction worker who was driving a road roller, big 6-ton machinery, straightish road, normal weather, nothing unusual at all. He fell into a ditch, the machine rolled on him, and he was unfortunately killed through crushing injuries. And the officer on the scene made some important comments which were actually brought out in the coroner's inquest. And one of them was that, well, he may have been distracted while he was driving the digger, but given it goes, I think, was at 24 kilometres per hour, you would have thought a distraction could have been easily dealt with. But he said also that he was affected by fatigue at the time. Now, unfortunately, the case didn't go further to say why the officer believed that, but it's a direct link in this case, and it's one of the few I've found, where fatigue has been identified as a direct reason for the accident. And also, as we see in often these cases, he had cannabis in his system at a level that was likely, or they said was possible, to have caused impairment and caused the accident. So this case with fatigue and impairment resulted in a guilty prosecution by the employer, and because it was guilty, we don't know the sentencing details, but certainly it was a guilty prosecution against the employer. But the coroner's findings were quite important in terms of recognising, and this was a 2006 case, recognising then that fatigue can cause accidents, and certainly employers can be prosecuted. In this case, though, because the employer didn't have a rollover cage or seat belts, they were prosecuted under the regulations for different reasons. So in terms of fatigue in New Zealand, and WorkSafe will be able to update me on this, but I know you've got the 98 document, which is a very good document. It states it's not a guideline, but I suspect it kind of is. You then have that update in 2003, which is a good guideline. Not a code of practice, but certainly a guideline, and they're very helpful. And I've seen today there's that helpful fact sheet. So these documents, along with that Australian document, should be enough information for any employer to start developing, with outside assistance where necessary, a good fatigue policy. How do you identify it? Who's responsible? What do we do when it happens? And of course, the Canterbury Rebuild Safety Charter there at number 9 talks specifically about this, in terms of safety of people is not compromised by either drugs, alcohol, which I think is impairment, or fatigue. And again, there's discussion there about having drug and alcohol policies and also fatigue policies. And I, from an employment perspective and also specifically from a health and safety perspective, I would recommend any construction organisation would have both drug and alcohol and impairment policies. There was one private prosecution a number of years ago which dealt with fatigue, and I've just mentioned it here. It was back in 2006 where an individual was driving home, and he had worked 21 out of the last 28 hours. So obviously there was excessive long shifts and there was limited breaks in between. Again, there was cannabis involved, but in this case it appeared that the cannabis was not seen as a cause of the accident. So he was driving home, and apparently he was 45 minutes into his drive, so we can only assume he works a long way away from his workplace, and he, I think, crashed his car into a ditch or into a tree and unfortunately died. And This was the EPMU who were taking this case, and I remember at the time thinking this was one of the first private prosecution cases, because private prosecution cases were entitled to do that after 2003, and they withdrew it. I'm not certain why, but certainly between the employer and the EPMU, they came up with this public statement that the parties recognise that fatigue is an issue the legislation has now made it clear must be addressed in the workplace, and we're working together to ensure that there is not a repeat of this tragedy. So a real recognition very soon on after the amendments in 2003, both from an employer and union perspective, that this is an issue. I'm just going to deal briefly with drugs and alcohol because it is clearly part of the definition of hazard, and it is clearly one of the obvious impairment aspects. And there's just these three cases here. The first one, again, is an employment case, Engineers Union against Air New Zealand. And in there, the judge said specifically, this is employment court again, that you must turn up to work substantially free from the influence of alcohol and drugs. And I struggled with that to begin with. I would have thought everybody turns up to work with no influence of alcohol or drugs. And then you go out for a lunch and you have a beer and you think, well, actually, I am substantially free, but I'm not totally free. And you've got a cold and you take cough medicine. You have some form of alcohol in your system. So it is correct. And in the second case there, an absolute tragedy where an individual driving a laden truck slipped down a hill, hit a house that was being worked on by a whole lot of gentlemen, and 2 people were killed and 2 were badly injured. Now the truck was overloaded. The weather conditions were bad. There's a whole lot of other aspects, but he had some serious drugs in his system, but at a minute level. And the doctor specifically said, well, this would not have caused the accident. It was caused by other factors. So what it says to me is that from a legal perspective, turning up to work substantially free from drugs and alcohol is the standard that we have to accept. Now, there may be, and the judge recognised this in the first case, there may be some organisations where you actually have to turn up to work totally free of drugs and alcohol in the system. And in the construction industry, there's probably a large number where, driving cranes or driving heavy machinery or working from heights, where that could be a realistic demand on your employees. But the last case was an interesting one. This is the meat workers. Department of Labour, as it was in those days, determined not to pursue this case for reasons I'm not aware of. The Meat Workers Union took it on and was successful. But in that case there, the employee was severely impaired, not just substantially free, but he was severely impaired by drugs. I think it was cannabis in his system. But the employer was still liable because it didn't prove it had trained or supervised this employee. So the important point about that case is that, even if an employee does have an obligation under Section 19 of the Act to ensure that they are safe and that their actions don't hurt others, doesn't matter, because if the employer has failings in its health and safety systems, it will still be prosecuted for those failings. Now, the fact that the employee being under the influence of drugs or alcohol will certainly limit the penalty, and in the district court they were fined $23,000. And 5,000 reparation. So just be aware of that. It is still the employer's obligation. So what can you do about it? What are the employer's rights? The first is an alcohol and drug policy. In the construction industry, I think it's mandatory. You should have one. Now, some people will say, well, it's not our culture. We don't want to put our staff through that sort of rigmarole. But it is something that if you are prosecuted and somebody is either affected to a limited or to a greater extent, and you don't have a policy, that will weigh against you. That is not a practical step that you have taken. And in looking at your drug and alcohol testing, first of all, safety-sensitive environments, random testing is entirely acceptable. The courts have held that. Outside of there, you would test on pre-employment. Some people will test on promotion within an organisation. So if someone's promoted from one level to another, especially into management, they're tested. Certainly on accident. Or suspicion, but the policy needs to be there, and you need to follow it to the T. And you have to decide: do I want a 1-step or a 2-step policy? 1 step and you're out, or 2 steps and you're out? My view is, depending on the organisation, 2 steps is usually appropriate. Think about rehabilitation. Do I allow employees to be rehabilitated and they can come back after that, and they can suffer some pain along the way in terms of not being paid? But is that something I want to do in my organisation? And then think about levels as well. Do I have a zero limit for alcohol, for example? So while under the New Zealand transport law I could drive a bus full of tourists around the winding roads in Kaikoura and have a couple of beers on board because I'm under the limit, do I say that's a zero limit coming to my work? And you might say, well, if you're operating heavy machinery, yes, zero limit's appropriate. You might say elsewise, well, maybe not. So things to think about, limits and rehabilitation and 1 or 2 step. And just another one, and a lot of people don't realise this, and why it's under the Holidays Act I don't know, but it is. It's under the Holidays Act. Section 68(4) states that an employer who is otherwise legally authorised, which means under your employment agreement, can stop an employee coming to work if there are relevant health and safety concerns. So if an employee wants to turn up to work and you think that there are relevant health and safety concerns, you can stop them. And you can say to the employee, until you get a medical certificate to say that you're fit and well to come to work, you can't work. Okay, and so that would be if you assess someone is fatigued. You know, a workaholic or someone who's going through a rough patch at home and they're fatigued, you can stop them coming to work. Someone who's under the influence of alcohol and drugs, clearly you can stop them coming. So it's a very useful section which we have utilised quite a bit. And the argument would be that, well, if they're going to get tested, maybe you have to pay for them to see a doctor, but you certainly don't have to pay their salary while they're away because they're not really willing and able to work. And if they're not entitled to be paid. So something to think about in terms of how you can actually proactively run a good health and safety regime at work. I'm just going to leave off with the Health and Safety Reform Bill. There it goes, double-sided. It's a massive thing. I'm not going to go through it in detail because I think everybody's probably heard enough about it. But I am going to talk about personal responsibility under that bill because that's one of the greatest changes, I think, and one of the biggest impacts we're going to see in New Zealand. The first is there are new duties for officers. So currently officers under Section 56 of the Act, you can be a party to an offence and liable. So the ice store, the cool store that exploded up Hamilton Way where a fireman rushed in to suppress the fire and was killed, there a director of the company knew about the flammable system used in that cool store, knew it was something which could be dangerous and didn't tell the fire service about it. So he was prosecuted as an officer and fined, and there's been a number of other cases along those lines. But under the new Act, it's going to be a lot more prevalent where we find these prosecutions occurring. And there's obligations of due diligence for officers. So whether you are a director of an organisation or a general manager or a CEO, even a CFO, legal counsel, or a senior advisor who makes decisions rather than simply advising on the whole or part of the organisation, you may be an officer under the new Act and you may be personally liable. The liability is up to $600,000 plus 5 years imprisonment. Now, that's not the bad news. The bad news is you cannot insure against the fine. You certainly can't insure against imprisonment. You can't be indemnified, you can't waiver, you can't contract out. So as officers of an organisation, you're soon going to have personal responsibility. We take it to the level where you know somebody coming to your work is fatigued, yet you need that person there that day to do the work. They go do the work and they're injured. If it could be proved that you knew they were fatigued, maybe you are responsible. And then we're looking at these sorts of things. So, personal responsibility now, I think, is going to become a lot more important under the new Act. And lastly, obviously, workers can cease to do work which is unsafe. So if someone themselves is fatigued or they see another person's fatigued who's double teaming them on a job, they can stop work and say, no, it's unsafe. There we go. I think questions. A little note from my insurer. This is just a brief discussion about issues of health and safety. But we are contactable at a very modest fee to talk about these things in more detail. And there's just part of our health and safety workplace law team at Neave. There we go. Thank you.